A person must know and approve the contents of their will. Where a will has been properly signed and witnessed, and has what's known as an attestation clause, the starting point is that the law presumes that a person knew and approved their will. However, that legal presumption doesn't arise in the case of a will signed on behalf of someone who's either deaf or mute or blind. That's why a properly drafted will should record that the will's contents were made clear to that person. The legal presumption of knowledge and approval can, however, be overturned, for instance where there are suspicious circumstances suggesting that someone wasn't aware of what they were signing. In that case, it might be possible to contest a will. In such a case, the burden of proof is on the person seeking to uphold the validity of the will. Examples of such suspicious circumstances include where a person who benefits under a will either prepared that will or had a key role in its preparation, where the person who made the will was suffering with some form of physical or mental impairment, which left them vulnerable and susceptible to the influence of others. For example, being drunk when signing a will has been held to be a valid reason to raise a presumption that a person lacked knowledge and approval. Another example is where a testator is very old, or where solicitors fail to explain the contents of the will to the testator, where there's any suggestion that they were subjected to fraud or misrepresentation, or where the will is just completely different to any earlier wills or known wishes. In the 2010 case of Gill and Woodall, the court held that Mrs. Gill, who suffered with severe agoraphobia, couldn't have known or approved the content of her will. It was found in that case that she'd been taken to a firm of solicitors to make a will at her husband's insistence. He was described by the court as being domineering and short-tempered. Expert medical evidence suggested that her panic and anxiety at the prospect of leaving the home rendered her unable to know and approve the will, and it was therefore set aside. As with cases looking at testamentary capacity, often the medical evidence, will-making file, and witness evidence of those who knew the testator are key.